the different kinds of policies up front and let the client make the decision as to what the appropriate thing is. I think as a trustee, you have to meet with the agent every year or more than one agent, get proposals based on their age at that time and for different types of insurance, and make sure that there's not a better deal out there. And then you got to convince the client to get examined again. We know how easy that is. Yeah, Tom?
Policies go up and they come down. Life insurance is low, so you rewrite it. But there's all these policies have penalties. So switching them every year.
I'm not saying switching them every year. I'm saying analyzing them every year. You may never end up switching it.
Right.
But I think that as a trustee, that you have to analyze it every year. Yeah, and so, I've been involved in a number of situations where the arbitrage is huge. You go out and you sell the policy, you take that money that you got back, buy a paid-up higher death benefit policy, and the client never has to pay a premium again. I mean, there's a lot of opportunities, but as the trustee, you have the obligation to go out and look at those opportunities. Yes, Michael.
What about grandkids or remaining beneficiaries? Mom and dad set up a trust, holds assets, holds insurance, holds whatever. The reporting of it is to the direct beneficiaries. What are the trusts you just named?
No, the reporting isn't to the direct beneficiaries. Under the statute, the reporting is to the current beneficiaries and the beneficiaries that would take if those beneficiaries died.
So, my point being is you have unnamed, unborn potential grandkids. Is that...
Well, the unborn ones, you don't have to serve an accounting on them.
But you have to go back to see who...
But yeah, you have to inquire every year.
2 kids, last 5 years.
Absolutely. You have to inquire every single year. Mitch?
Are you saying that you must send the accounting annually to even the future beneficiaries?
The beneficiaries that take if the current beneficiaries die. So in most cases, let's play it out. In most cases, it's going to be the children and the grandchildren. And so, yeah, you do have an obligation.
Even when they're minors?
Even when they're minors. Now, the representative may be the same person that's the current beneficiary, but you still have that obligation. Except, let me get to the important part here. Okay, as I said, that you can appoint a representative. The grantor can do it, or it can be done subsequently. And the service, any reports sent to that representative has the same impact as if it was sent to them directly. The categories of representatives are the fiduciaries, who are the people named a guardian, a trustee, a parent of an unborn or minor child is deemed to be the guardian. Virtual is if they're not represented, someone that's represented that has a similar interest. Let's say client sets up a trust for their 2 children, and one of them has disappeared off the face of the earth. And so that leaves only 1 child left. You can actually serve, because you don't know where that person is. If you've done a diligent search, you can serve the accounting on the other child because their interests are identical. Okay? And then there's the court-appointed, if there's a court-appointed guardian or someone like that. Those are the different types of representation. Okay? Let me get to the important part. All right, here's the important part. This is the accounting portion of it. And you have an obligation to account every year, and you have to disclose the following information. You have to start with a statement of where you were at the beginning, show all the ins and outs during the year, and then state where you are at the end. Okay, and that includes the life insurance policy showing what the cash value was at the beginning and what the cash value was at the end. All right. Yes.
Are you seeing a trend with corporate trustees that are now faced with this increased liability to charge more?
Well, you're seeing 2 trends in corporate trustees. First is they will not be and I'm generalizing, but they won't take on a insurance trust any longer unless there is a significant relationship secondary to the insurance trust. Okay? And then, as always with corporate trustees, the fees are negotiable on that part of it. But they won't take on an insurance trust any longer just as an insurance trust. There has to be another significant relationship there with other assets. Okay? Yep.
Stu, just very generically, grantor versus non-grantor trust, I've always been told there's tax advantages, but I really don't understand, like, most of the deals I work on are grantor, but what, can you just?
Yeah, quick diversion, the difference between a grantor and a non-grantor trust. In a grantor trust, for income tax purposes only, the grantor is still deemed to be the owner of the trust, and any taxable activity in the trust is taxed to the grantor personally. A non-grantor trust is a trust that is its own separate taxpayer, and it's taxed to the trust unless distributions are made out to the beneficiaries, in which the tax characteristics flow out to the beneficiaries. The big reason that you see a lot of transactions with grantor trust is because any transactions between a grantor and a grantor trust are invisible for tax purposes. So you can buy and sell all day long between a grantor and grantor trust, and there's no taxable income or no taxable loss reported. Okay? And that's why we see a lot of that. Okay? On the final accounting, the trustee is required to show a plan of distribution, how the assets are going to be distributed out. Here is the key, okay? The key are the waivers and the use of investment statements. Now, I painted this horrible picture of what every trustee has to do. The trustee can get a waiver from each beneficiary saying, I know that you have an obligation to provide me with an accounting. I hereby waive any future service of an accounting unless I ask you for it. So now we can send, if all the kids, mom and dad set up the trust, and they really don't want to have you account to the kids, they can have the discussion with the kids saying, we really know that you have the right to accounting, we want you to waive that right. Here's this form, sign the form, you don't have to, we don't want you to have the trustee require accounting to you. And that usually is done for one of two reasons. One is they don't want them to know what's in the trust, and two is they don't want to pay the accounting fees for the preparation of the accounting.
There's also a third very important one, is they don't want the evil spouse of their child to know what's involved in the form.
That's possible as well, although that never happens. But